It's amazing joining us on a fresh episode of Law and You. We take our time to look at issues surrounding the law and how to bring respite to the viewers, basically, in order to clear gray areas that may seem shady to you as viewers. My name is Philip Omo. Last week, we hit the start of the journey on defenses to crime, and we are, let's say, midway on that journey, but we are not yet on our destination point. And looking at what we have today is the part 2 of the series, Defenses to Crime. And we're going to be having a very outstanding legal practitioner to discuss this part of the episode with us. And don't forget that Law and You is brought to you courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. Last week, we had a head start on this topic with the legal partner of Noah Attorneys, and unfortunately is very busy and unable to join on this episode. But basically, we have an opportunity to enjoy the presence of a human rights lawyer and a public affairs analyst, and he is Emmanuel Obakbolo. Thanks for joining, Emmanuel.
A delightful afternoon to Nigerians. Good afternoon, Philip.
All right, thank you so much. And let's look at the perspective of defenses to crime. I agree there are numerous branches and various ways to navigate this topic, but let's look at the aspect that concerns one taking an action, to attack another and will be seen as justified in the eyes of the law, looking at the defenses to crime. So at what point can one do that?
The law in Nigeria, particularly in the southern part of Nigeria, does provide for defenses to criminal liability. And before we could go that, how can a man be vindicated, or what are those remedies, or what are those excuses, or what are those defenses that are provided for a supposed violator of the criminal responsibility. So what are those defenses that are provided for? First of all, we look at what are defenses. Mm-hmm. Now, by virtue of the law, the criminal code, it says that a person who commits an offense or omits, independent of his act or omission, that person can be said not to have committed that crime. That is, if the person unknowingly, if the action or the omission that is taken by that person is not something that was within the knowledge of the person, as at that time he so commit that act or omits to commit the act, then you cannot now bring it as a criminal responsibility on the person. Instead, there is an excuse, there is a defense that is provided for by the law for that person.
On that, there are defenses, on that excuses.
Yes. Now, you look at, for instance, Section 24 of the Criminal Code, provide for accident as a defense to criminal liability. So, where there is an accident, for instance, we have the Federal Highway Act also, that also regulates the activities carried on the highways in Nigeria. So, the Federal Highway Act has its own provisions, but the Criminal Code, wherein the person could be charged for, in addition to the Federal Highway Act, already provide that accident is a defense to criminal liability because it is done not within the exercise.
It's not a deliberate act.
Yes, it's not deliberate. That is the language, because now we are talking to our audience. So we want to see that we make it, so my choice of language will also be try to make it simpler for those who are listening to us. It's not grammar always.
Yeah.
So accident is a defense to criminal liability because it is not deliberate. 1, 2, it was not done knowingly. Still, then 3, it is not within the person's power to or control for that act or that omission not to have taken place.
Okay. Well, just as you made mention, let's also pinpoint the aspect, because if we say that we have excuses for committing crime and we can be excused by the law, let's look at the aspect of insanity, for instance.
Good.
Does it fall in line?
Yes.
And how can one use that as a yardstick to be excused from a crime? committed?
Yes, for instance, where a person is mentally derailed, or he has some disease of the mind, which is known as insanity, and that person commits an act, that person could be excused for the commission of that act, even where that act happens to be a crime. If, for instance, a madman takes a stick and hits another, he has defense, because as at that time he cannot control his mind. But however, there are exceptions to that rule.
Exactly.
Where the person is in his lucid moment and he commits that act, or he omits to commit that act, he cannot use insanity as a defense.
When you say lucid moment, it depends on how the medical or clinical researches can be done to determine if it was at the lucid moment or not.
Yes.
But otherwise, if somebody has an element of insanity, ordinarily that's an excuse for any crime that may be committed.
Yes.
But we'll now be looking at what point, at what time that crime was committed, and using it to juxtapose its level of insanity or sanity, as you may say. But let's go back to the first question I asked you, because I don't know how you maneuvered your way out of that. But let's get back there, because it's quite important. A situation where one has an ability or has a legal backing to attack another in self-defense. Is it right?
Yes, when you talk of self-defense now, self-defense can only be an excuse or a defense to a person who so exercises that privilege, where it is within a dwelling place.
Okay.
A dwelling place. You cannot, for instance, go to your shop or to your office place and say that, oh, I try to exercise the privilege of self-defense when Mr. ABC attacked me with a gun or with a wood or with any weapon. You cannot do that.
But at the point where you are a gun is pointed at you, basically it will be an act of self-defense if you are able to do anything to excuse you from being shot by that. If you are able to do it smartly, whatever comes, even if you are able to attack who's pointing a gun at you, will the law frown at it? Because pointing a gun at you already is a criminal case. And so if you are able to get yourself off that challenge, and you are able to, do anything that will keep yourself protected, even if it means harming the other, is that not self-defense?
No.
Oh.
That cannot be self-defense.
When a gun is pointed at you?
The law says a dwelling place, your house, where you stay, where you live.
Okay, so if it's not a dwelling place, a gun is pointed at you in any other location, what do you do as self-defense?
Well, you could maneuver your way, but the degree of injury you also inflict on that person will be another issue for arguments.
When a gun is pointed at you in the first place, that's threat to life. Because if the trigger goes off, it means that it will be under probability that the person will be alive, that received the bullet.
What if, for instance, the person holds an empty gun, or it is a rubber pistol, and Mr. A comes with a rubber pistol and points that rubber pistol at Mr. B.
That ordinarily shouldn't be a case for the victim, because in the first place, even if it was done under pretense, but a gun was pointed at him. Or is it a case that can be marshaled out in court?
Yes, that is why the law provides for defenses to criminal liability. If, for instance, like I was trying to paint out a scenario where A takes a rubber pistol and points at B, and B brought out a pistol and shot at A, will B now say it was as a result of self-defense?
Maybe at that point the victim was thinking that it was a real gun. How do you tell at that point? Because at that point you may be under duress, because that's another aspect of looking at defenses to crime. If one acts under duress, one can be excused.
I don't see
because you may not necessarily be able to judge particularly if that pistol was a plastic one or a toy gun. You may be thinking that it is a real gun, because at that point you can't do anything to protect yourself. So how can the law excuse the action of a victim who defends himself in that direction?
Well,
And later found out that it was a toy gun.
well, the common man would reason in your direction, in the way you are painting out. But with the law, the law has some elements that must be proven to show that, yes, this act was in self-defense. But where you are not able to prove some of those ingredients that will enable the defendants now enjoy the privilege of defenses to criminal liability,
Okay.
then he will face the law squarely.
Okay, but let's look at it critically. Is it even right for someone to point even a toy gun at another person?
It is not right, but that is not also a license to kill. It is not a license. That's why the law look at the common man, the reasonable man's test.
Yeah.
The way, how would a reasonable man figure out this? If, for instance, a man comes with a gun in a crowd and points at B with a gun in a crowd. In a crowd. So, would B now use the privilege of self-defense in attacking A in a crowd and say that, oh, I only wanted to exercise my privilege, the privilege given to me as defenses to criminal liability, self-defense as a defense to criminal liability? The law will frown at that.
So it has to be at a dwelling place, for instance, like
a dwelling place. And the degree of reprisal that you carry out is also an issue.
Okay, it must be proportionate.
Proportionate. That is the issue. That is the,
Take, for instance, someone points a real gun at you. No. Take, for instance, someone is using a stick to attack someone, and then the victim now uses a gun. That is not proportionate.
It isn't. And you cannot now rely on the defense of self-defense with respect to not being liable to that crime so committed. You cannot.
Okay, in case you're just joining us, it's Law and You, and we're hitting your screen already, and you can see the numbers on the screen. If you're not saying it, you should say it a moment from now. Just do well to react to whatever you want to react to as on what we've been talking about on defenses to crime. And my barrister that has been on this with me is Emmanuel Obakbolo, and I am Philip Omo-Gukmon. Let's look at another aspect. Well, still within. You know, you made mention of a dwelling place. At what point can one make an attack on someone in self-defense if his presence in his dwelling place is threatened?
If, for instance, A is in his dwelling place, a fenced house with a gate, and suddenly B climbed the fence and entered the house, it shows that B has come with a mission.
That's a trespass.
Yes. Comes with a mission.
Even if it's daytime?
Even if it is daytime
if someone
or
climbs,
at night.
If someone climbs the fence or jumps over it,
yes,
and produces a very good reason why he or she did that,
if, for instance,
can the law still frown at it?
Yes,
depending
if, for
on
instance,
what he or she says?
a mob is chasing him, a mob is chasing B,
Okay.
and B jumped the fence into A's house, and A comes out with a stick or a wood or a gun and hit B and B dies, A cannot claim self-defense. He cannot.
Because the victim that died
was being chased by a mob.
Exactly what I mean. So there must be a circumstantial story.
Yes.
To tally with
the
that.
Evidence.
A circumstantial evidence.
The evidence. So, but if while A is in his dwelling place and B comes and jumps the fence without any atom of threats to B's life, and he now enters the living room of A can exercise self-defense, the privilege of self-defense.
But does it not also depend on the story that could follow that action?
That's circumstantial.
Take, for instance, the apartment is already open, maybe during the daytime, and just like you said, being chased by a dog, and this person in question happens to be very, very apprehensive and scared about that. And in the process, was able to, scale the fence, and then saw the door on the apartment open, and then found his way in, just because he wanted to escape from what was chasing him or her. So is that not also a circumstance that could give such one who breaches or trespasses the reason why he shouldn't be apprehended?
Yes. No, apprehension, meaning the man who jumped the fence is being apprehensive. And in order to save his life, he looked for a place for rescue. And A now comes out and says, oh, you jumped my fence.
And attacked.
And attacked him and killed him. A cannot depend or cannot rely on criminal defenses to criminal liability. Self-defense is one of them.
Okay, take for instance, death wasn't involved, or it didn't get to that point. Maybe injury.
Grievous bodily harm.
Yes. Does it make the owner of the property right?
Guilty.
Oh.
Guilty. Because circumstances.
So at that point, what should the owner do, or the one that is in the dwelling place? What right does he have if someone trespasses?
In order to protect himself and family members, there is also the probability of applying caution.
And
the
patience.
Application of caution.
And patience.
Yes. You must apply.
So you don't act
caution.
as impulse.
Your action must be proportionate with that carried out by the victim. So the law looks at the circumstances. The law looks at the ingredients. The law looks at the action. The law looks at the omission. The law now looks at the intent. Why did this person do this? Why didn't he do it the other way? So the law looks at all of this. So even while you exercise some of those defenses to criminal liability, the magic word there is the application of caution. And the law will look at what would a reasonable man, what would be the action of a reasonable man with respect to what has transpired.
I think you gain knowledge on this conversation we're having with Emmanuel Obakbolo, a legal practitioner. And basically, don't forget, Law and You, it's coming your way courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. Well, we usually see in houses where they say, keep off, danger, mostly when the fences are electrocuted. You've seen all that. They say, keep off, danger. I don't know if the owner of the house eventually turns the switch on at night. So if that happens, and then maybe someone just coming in the night who happens to be a relative or a friend, without knowing it, touches the gate and is also electrocuted. Who takes the blame?
Well, it depends on the circumstances. At what time of the night? If the relation or relative comes,
is there a time that we can term
yes,
unholy?
The law will look
because
at
politicians
yes.
at a time back said
yes,
unholy hours.
The law will look at that. That's
So
why.
What hour is unholy?
The intent of one, it depends on the environment. You also consider the environment.
Yeah.
If the environment is a hostile one, and there is the possibility or the occurrence of crime in that environment, and the man has said, oh, the only way to protect myself and members of my family is to get this gadget to secure myself, particularly throughout the night. Then the man switches off the gadgets. So if at a particular time of the night,
does the law have a particular time where it's unholy?
The law will not.
Let's use that word by politicians. Where it is unholy for anybody to go close to the gate.
Yes, you know, the law looks at...
Because there's no curfew. So if there's no curfew, then what stops you from moving even in the night?
No, whether...
A drunk man can make the mistake of, leaning on the gate. That is electrocuted. And you may mention the fact that, okay, well, we've not gotten there. Like intoxication, for instance, could also make someone to make such mistakes. And he would be excused by the law.
It depends. So, if the intoxication is voluntary.
But for us not to have direct thoughts, but let's look at this. Is the owner of that dwelling place right to have done that, even though there is already a sign, an inscription, danger, keep off, and he switches it on in the night?
That's why I said
Does the law frown at that?
the law will not frown at any man that wants to protect himself and members of his family. But the circumstances.
So if anybody gets killed in the process, he's
yes,
excused.
It's excused.
Wow.
If the circumstances so spell it out that, look, one, there was no intention, or the intention was to protect himself and members of the family, then at what time of the day? The man wouldn't want to switch off those gadgets, let me say, by 7 p.m.
Let's say 12 midnight.
12 midnight. So 12 midnight.
But again, we can't say 12 midnight because it depends. Because we even have crimes, committed. Armed robbery even take place anytime. Even 8 p.m.
I agree with you.
9 p.m. Even 7 p.m.
I agree with you.
So
absolutely.
for the purpose of being cautious, such a man could switch it on by 8.
When it happens in that circumstance, the law will look at the intent of the man, just like I've said. 2, then the defendant, the deceased, if the person dies or if there is a grievous bodily harm, the victim, at that point in time, what was his action? What did he go there to do?
Well, the person is already dead, so you can't question a dead man.
The dead.
But like you said, well, you've said it, but I think this will provoke some thoughts for us to pan out or churn out another episode that relates to this. Because is it really right for us to electrocute our guests? That's another thing for us to talk about. But like you said, if it's for the purpose of protecting one's family, most especially if the area wherein the dwelling place is a flashpoint for crime, what stops the man from doing that? But are there legal documents that should be tendered or that should be processed for someone to have this gadget on in his or her dwelling place?
Well, I don't think it is an offense, because the law says any offense that is not known to law is not an offense. I will call and fact by me. So the principle is clear and express.
Okay.
So any offense that is not known to law is not an offense. So having those gadgets, I don't think that the law prohibits having those gadgets. So if one does have them, it is not a crime.
Okay.
That is what I think is the position of the law just now.
Okay.
But however, like I told you, the circumstances that led to any situation where we now have a victim and a defendant, then the law will have to look at the circumstances, the law will have to look at the intent, and the law will have to look at the commission and the omission by either of the parties to see whether or not a person or the other person or persons, as the case may be, are guilty of the offense. But the law, stricto sensu, provides for defenses to criminal liabilities.
Okay, just to let you know, it's Law and You, and we will be taking our last lap on it, but don't forget to react to the numbers on the screen, and whatever questions that you want to ask, you can interrogate on those numbers. We will basically reach you and also use that to pan out a new episode. And it's been awesome having a chat with you, but as a round off, let's look at your urge or your advice for people who could be victims of crime, though by duress or by any of these challenges that they could be faced with. How do they address these problems, or how do they make their cases known before the court so that they can be heard?
Well, when you look at the criminal liability of defense of duress, most times you discover that when it has to do with, you discover that it is the security agencies that are more into such acts.
Okay, but I don't know if you got my question rightly.
I got it right.
Yeah, because some could be victims who may be, prosecuted by virtue of the crime they committed, even when they were intoxicated, or even when they had insanity or in that mental paralytic stage, or even when maybe they were really victims of being pursued by other criminal elements that made them to do that, whatever crime. So if they are being prosecuted, how do they approach the legal counsel, or how do they get legal counsel and approach it?
We have the Nigerian Legal Aid. You can also approach the Nigerian Bar Association, and if there's any lawyer, we have so many lawyers who are ready to take up such matters as pro bono,
okay,
free of charge.
Okay, free of charge. Exactly
Yes.
where I'm going, because some may
Yes.
not have the wherewithal
Yes,
to prosecute that case.
They will take it as pro bono,
Okay.
and ensure that justice is done.
All right.
Because as lawyers, our temple is the temple of justice, and we have just one mission, and that mission is to ensure that there is justice.
Thank you again and again. Emmanuel Obakbolo, a seasoned legal practitioner. Big thanks for pulling through on this episode of Law and You Defenses to Crime. I don't know if we're going to have a continued series on this, but it depends on what you do. If you react to it, or whatever way you swing the pendulum towards, maybe our thoughts could go there. I am Philip Omo Gupo. We'll do the same time next week. Goodbye.